With regard to personalized medicine, what we're talking about is this last element, if you will, the natural phenomena or natural principle. And that's kind of where this patient information, and again, what I mean by patient information is genetic information generally, not certainly height, weight, well, height, weight can be, as well as background of the patient, family history, things like that. But more so sort of this concept of natural correlations. So the idea that an elevated level of some metabolite, an elevated level of some protein provides you with information about how a patient reacts to a particular method, how a patient reacts to a particular medicine. Again, Mayo v. Prometheus, I think we're all familiar with sort of the elements here. Comment I'll make that this sort of really set out in broad terms sort of the goal of personalized medicine. Again, the idea of taking information, utilizing that, and based on that, providing what you should do in reaction. And the court said with regard to sort of, again, these three steps, administering, determining, and then the where-in clauses, that with regard to the administration, you were a pre-existing audience. So it was already doctors that had treated these patients with this specific drugs. With regard to the determining, these words will come up a lot, but using well-understood routine conventional activities, simply taking a blood test, doing some type of of analysis that was routine in order to determine the level of the metabolites. And then the where-in clauses were basically just adding or just stating what was well known or what was, again, a natural correlation. So however, if you were above a certain level, you needed to do X, below a certain level, you could do Y. The comment that I'll make, and we've sort of given the Supreme Court a hard time, the Supreme Court has a policy, I don't know, of taking cases where the claims are not very well written. And in my view, taking those claims and making a very broad decision. If you look back even at the KSR decision with regard to obviousness, those claims really weren't drafted all that well. And rather than making sort of a narrow decision, they came out with 8 additional ways that you can determine obviousness, and now we're dealing with that. With regard to Mayo here, again, if you look back at the claims a little bit, you really only had 3 things, in fact 2 things: administering a drug, determining a drug, and figuring out that those levels meant something. So it's sort of a byproduct of, and Bob Stoll talked about this yesterday, of claims that probably weren't drafted very well and maybe shouldn't have stood up, but by taking that, or by the Supreme Court making this statement, really issued this broad sweeping language again that anything that is well understood, routine, or conventional isn't going to be enough to get you over that hurdle of patent eligibility or ineligibility. The last little quote here that I want to focus on, that the steps are not sufficient to transform the unpatentable subject matter. And I want to focus on the word steps. And the reason is we're talking about, again, methods. So kind of the theme that I want to talk about and have you all think about is when you're drafting claims like this, when you're trying to cover inventions directed to personalized medicine, add steps. That's what we're going to have to do in the U.S. in order to get these things patented. And that will kind of come through as we look at some of the cases that have gone through. So these are the flow chart, if you will, that the Patent Office put up on its website back in July of what the examiners do when they get a case. So the first thing you're supposed to do is it directed to a process, machine, manufacturer, composition of matter? If it's not, well, certainly it doesn't meet the statutory requirements of 101. We don't even have to worry about it. If it does, then the second question is that claim directed to a law of nature, a natural process, et cetera? If it isn't, we can go through and examine it as we would for novelty, obviousness, written description, et cetera. If it, however, is directed to one of those judicial exceptions, we now have to do part 2. And part 2 is where all of the action is, all of the concern is, and unfortunately a lot of ambiguity is. So the comment, or again, question that the examiners are asking themselves and that we as practitioners need to ask is, does the claim recite additional elements, and I'll say steps in some cases, that amount to a significantly more than that judicial exception? So what are some of the things that the Patent Office has said probably would amount to more than that? So they've said something like improvements to another technology, affecting a transformation or reduction of a particular article, adding a specific limitation, and this is again where this idea of something other than what was well known, than what was routine and conventional, might be able to overcome that hurdle. and then some other meaningful limitation. So whether or not this provides you with much guidance, we'll talk about that. The thing that has come out in a few of the talks yesterday and today even, adding treatment steps. So how does that work? I've had quite a lot of success in the US of getting claims where we add a method of treatment or adding a treatment step. Certainly the problem with that, and that has also been addressed, is, well, and how do you prove infringement, or how do you show infringement when you have maybe two parties, a doctor and an external lab doing the testing and then the doctor doing the administering. The comment that I make to my clients is, if I add a treatment step, I can probably get you a patent. That patent allows you into the game. It allows you into the ring to fight. It allows you to get to the table to negotiate, and it may allow you to get a settlement, keep someone else out. If we don't do it, you don't have anything right now. So it's kind of the concept of if that is of use to you, again, and if you think it does encompass what you're interested in, adding a method of treatment is certainly a way to go. And the other thing that it does is, if you fight that claim, there's a lot of ambiguity with regard to how direct infringement is going to be found, whether or not there is enough of a relationship between the doctor, between the company doing the test, et cetera, that there may be an agency relationship. There may be some type of relationship where the parties are in enough control situation that you can find a single infringer. So again, my comments are, let's take that claim, gives you some leverage. Let's try and use maybe these other things in a continuation application if we go forward. So with that in mind, kind of what hasn't worked, and the case that was just mentioned, the Arios, the Sequenom case, again, I'll kind of comment that this claim really is very thin, if you will. All you're doing is you're removing a cell population, you're doing an amplification reaction, and then you're subjecting the amplified nucleic acid. And basically the court, as we've said that isn't enough. You started with something that was well known, you ended with something that was well known, and all you've really done is tell the doctors about this conventional activity. And it was simply just well-known, conventional, routine things. I sort of call this claim the ta-da claim, if you will, that all you really did is you removed something, you did an analysis, and ta-da, you have an answer. That's just not enough. What you need to do is you need to add additional steps that really spell out what it is you're going to do with that information that will help guide the personalized medicine, help guide the doctors. So there's a case, and it's not actually specifically personalized medicine, but it got us a little bit further down the road, and that's a homopet case. It's actually out of the District of California, but it was affirmed by the Federal Circuit relatively recently. So it's a method of formulating and preparing a nutritional diet. And what's interesting about it is if you look at the structure of the claim, it's basically the same as the Prometheus claim. You've got a method of analyzing where you're assessing data. That data is from information gained from a bodily fluid, a tissue. You're taking some additional information with regard to genetic information. You're analyzing, you're relating it, and based on that, now you're doing maybe a little bit more, maybe again, an additional step. You're formulating a nutritional diet based on that data, and in a dependent claim, you're actually preparing a diet. Unfortunately, this wasn't quite enough, but I think we're getting closer. The court and the district court said that simply stating, formulating, simply stating, preparing wasn't quite enough. That was just an extension of this idea of determining. But there were some comments in the case that pointed to if you had done more in the claim, again, if you had really spelled out a little bit more of how you're doing the formulation, how you're doing the preparation, that you might have added enough to overcome that hurdle. You might have done enough to get this claim into patentable subject matter. The other things quickly I just want to talk about are, I pulled some examples out of again, the guidance the PTO has given, as well as some other cases that we found where claims have at least been found patentable. The big caveat I'll make here is that not everyone has these elements at their disposal when they're drafting or even when you're working on an application. They're pretty specific, and however, they are, I would say, recognized as things that probably will work, help you get these methods allowed. So this, is sort of a draft or exemplary claim. Basically, again, in the language of Mayo, of Prometheus, and all you're doing is you're obtaining a sample, you're looking for the presence of a protein, and based on if the protein is a certain level, you want to administer the drug during the day. If it's below another level or below a level, you want to do it at night. Just a very simple claim. So what's one thing that the patent office has said? Well, if you do that analysis with a novel antibody, and I'll come back to that in a second, then that's probably going to be enough to not be routine and conventional. So what does novel antibody mean? Well, certainly in one sense, it literally means an antibody that wasn't known. The other way that you can look at it, there's a couple different ways. One is an antibody that has a mutation. So something that does not exist in nature would probably allow you to get this claim through, in that it's not a naturally occurring antibody, it's not a naturally occurring principle then, so therefore you'd be able to get over the hump. The other is that when I'm saying novel antibody, with regard to the reaction with protein Y, so if it wasn't known that a certain protein bound to a particular antibody, that again might not be a routine conventional activity, and therefore you may be able to utilize this kind of a limitation to get this claim allowed. The other, and this is a little bit easier to envision, is some type of a new technique, new detection technique, and whether that technique maybe in past had been used with other types of analysis, and now you're applying it to your particular analysis, and it was not routine, it was not conventional. That again probably will get you over the hump to get patentability. The other thing that you might be able to do is if you can again show that because of some modification, again this presupposes you have this available to you, because of the modification you made to the method, you're getting a higher binding. You're getting something that is so much better than what was out there before that it may again impart patentability to this type of claim. And then the last example I'll give is basically shown in the kind of the pictures, which is this idea that if naturally your antibody bound to your protein at a particular site, but there are hidden sites within that protein, within that structure, and it's only because you are extracting the protein, it's only because you're doing it ex vivo that you're ultimately getting the reaction, that you're ultimately getting to be able to determine the level. That might be enough, because again, that's not a naturally occurring, it doesn't occur in nature, structure. So that might be, again, something that would allow us to modify the claims to get these through. Again, as I said, these are all sort of examples that suppose that you have this available to you. Kind of what I'd sort of, again, say, and I mentioned in the beginning is, and echoed yesterday, really think about putting in your application, really think about putting in your claims with regard to personalized medicine, detailed steps of what you're doing, what beyond the natural correlation are you doing such that you can get them through the patent office. And then my last comment, or my last strategy, which I tell my clients, which they're not happy about, is wait. That's probably the best thing to do right now, is wait. The concurrence, again, that we heard about a minute ago from Judge Lynn, said that I'm bound by this sweeping language. I don't like Mayo. I really don't like to do this. The other interesting thing that came out of that was this wasn't a routine, conventional activity to look for the cell-free fetal DNA. It was something that no one had done. So taking that view of it might allow the Supreme Court to not go back on itself too much, but simply say, well, we said it isn't something routine and conventional. This wasn't routine to do this type of activity, so that may be enough to help them, fix what they've done, I think. However, the Federal Circuit doesn't appear to be able to do a whole lot right now. And then the last is certainly wait until Congress does something. I think, again, Bob Saul mentioned this yesterday, if the Supreme Court denies this or doesn't take it, which hopefully they will take the Sequenom case, there's going to be a big uproar. And the other thing that's unique here is in this idea of eligible subject matter, bio and IT, I think, finally are on the same side for once. In the past, they have been at odds in different things with regard to reform. But with Alice and with Prometheus and Sequenom, they're finally kind of together, and hopefully that would be enough to force some action. So thank you very much.